Okay, so I'm able to see Madam's bio here. Thank you so much, ma'am, for sharing these details. Firstly, I should be saying that I have been following ma'am's work through media reports regularly in all the leading cases which are coming before High Court of Telangana and in the city of Hyderabad and other places. So I was finding what do you say, Madam's name. So I just reached out to Madam. Thank you so much, ma'am. And next thing is, ma'am, Vani Madam has studied from about her education. She has studied from St. Anne's High School, Sikandrabad, and she has done her intermediate from St. Francis College, Sikandrabad, and she has obtained a BSc degree from Usmania University, and she has also obtained a LLB degree from University College of Law, Usmania University, and she has done a postgraduate diploma in industrial relations and personal management from Bhavan's College of Mass Communication and Management. So she has many educational degrees, and she has enrolled on 30th October 1980. So she's almost having 40 years of legal experience, and we are very much happy that such a legendary figure has come down to speak to us. We are really thankful to ma'am. And since the early period, like she branched out as an independent practitioner in law in 1983. She's been working on civil cases, criminal side cases, land grabbing cases, company matters, writ petitions before the high courts. She appears, she has appeared regularly before civil and criminal courts of Hyderabad, Sikandrabad, Rangareddy courts, and she has also, handled criminal matters at Meerut, Uttar Pradesh. She appears in Supreme Court of India, and she appears before other high courts of the country like Andhra Pradesh, Bombay High Court, Madras High Court, Bangalore, Karnataka High Court, Calcutta High Court, and Delhi High Court. And she has been appointed Special Public Prosecutor for social welfare scholarship scams between 2003 and 4. And she has been a member of Lok Adalat at City Civil Court Hyderabad and Metropolitan Criminal Courts Nampally. She is also honorary advisory, board member for All India Law Digest, and she has done, she has been involved in rifle shooting, that is at a national level. She has participated that in 1976, and also she has been the a member of the winning team, champion team, and she has attended over a lot of events, workshops, seminars relating to education on women's rights, and she has conducted these workshops at what do you say, National Commission for Women, I guess, and AP, Andhra Pradesh Mahila Commission, and several other organizations. She has been invited as a resource person at National Judicial Academy, Bhopal. That is the place where judges get their training. And she is a resource person for OU Academic Staff College, Central Detective Training School, Murray Channa Reddy Institute of Human Resources, National Judicial Academy of India, and at Bhopal, and several women's colleges in Hyderabad. Since the last, 17, 18 years, as per my understanding, Madam has been regularly appearing before all the top media channels, and she has been, what do you say, educating the masses in terms of legal education. She has been given a lot of awards for her phenomenal work. She has been given the Stree Shakti Puruskar by a voluntary organization. She has received the Maha Andhra Award in the legal profession by Telugu Employees Welfare Association, Delhi, and she has received awards for excellence from TV9 and Pingali Venkaya Smaraka Samstha, and she have received the NTR Memorial Award for excellence in legal practice, recipient of the Sabda Mahila Award in 2011. So I actually am reading a very what do you say, a very short bio of ma'am. So 40 years is a pretty big time, and she has a lot more achievements than which we could share here in this very brief time. So we are deeply, thankful to Madam to have agreed to speak to us on a very, very important topic and also offer expertise. So I welcome Vani Ma'am to this meeting, this online lecture, and thank you so much, ma'am, for coming. Thank you so much.
Good evening, everyone. Let us forget what Mr. Mahmood has read, and let us now concentrate on the Domestic Violence Act. Domestic Violence Act, as the very name suggests, is violence which happens in domestic arena. And when it happens in domestic arena, what kind of violence attracts this? There are similar laws in UK, US, India, in all the countries. In US, after the women's liberation movement and all that, they brought some law in respect of domestic violence. Then in UK there is law. In US there are laws in different states. Now, the major difference, see, when we go to the law in US, the definition of domestic violence in the US law and in the UK law, it is much similar to the laws in India, the Domestic Violence Act in India, because it covers all kinds of abuse, like our Domestic Violence Act does. Physical abuse, verbal abuse, sexual abuse, financial abuse, all kinds of abuses are covered under this act. But the major difference between the acts in the law in the other countries and our country lies in who is the aggrieved person under the different laws. Now we start with the law in India, and wherever necessary, I will make a short comparison if at all it is relevant, if it is within the context of the matter. Under the Protection of Women from Domestic Violence Act in India, what is domestic violence? Domestic violence, as defined in Section 3, is I may be permitted to read it out because there are a few important things which have to be read out because that would throw light on the entire matter and then we can understand it nicely. Any act, omission, or commission or conduct of the respondent shall constitute domestic violence in case it A. harms or injures or endangers the health, safety, life, limb, or well being, whether mental, physical, of the aggrieved person, or tends to do so, and includes causing physical abuse, sexual abuse, verbal and emotional abuse, and economic abuse. Then B. harasses, harms, injures, or endangers the aggrieved person with a view to coerce her or any other person related to her to meet any unlawful demand of any dowry or other property or valuable security. Or the third one is very important because this has a very huge coverage. Has the effect of threatening the aggrieved person or any person related to her by any conduct mentioned in Clause A or Clause B, or otherwise injures or causes harm, whether physical or mental, to the aggrieved person. Explanation 1, 2, 3, 4. We have this: what is physical abuse, what is sexual abuse, what is verbal abuse, what is economic abuse. Economic abuse, I would like to point out one small thing. Economic abuse is so vast in its definition, in its description, that it encompasses so many, so many situations and it gives protection to women in several situations. Now, before we go to deeper into this law, let us first find out who is an aggrieved person. An aggrieved person, you will see the definition in section 2a. Aggrieved person means any woman. So let us understand this, that this act deals with protection of rights of women guaranteed under the Constitution. So aggrieved person means any woman who is or has been in domestic relationship with the respondent and who alleges to have been subjected to any act of domestic violence by the respondent. And now, who is a respondent? Respondent is someone, one second. Respondent is any adult male person, but as law, has kept on progressing because of the uh, various judgments, it is not essentially a male. There are only a few sections which would not be applicable to a male. I'll come to that. Respondent means any adult male person who is or has been in a domestic relationship with aggrieved person and against whom aggrieved person has sought any relief under this act. Now, so what is the bottom line is there has to be domestic relationship between the parties, that is, the aggrieved person and the respondent. What is this domestic relationship? Domestic relationship means a relationship between two persons who live or have at any point of time lived together in a shared household where they are related by consanguinity, marriage, or through a relationship in the nature of marriage, adoption, or a family member or our family members living together as a joint family. Now, we can understand relationship by birth. We can understand relationship by consanguinity. We can understand relationship through adoption as family members of a joint family. Now, what is this relationship in the nature of marriage? Marriage, relationship by marriage also we understand. Now, what is this relationship in the nature of marriage? This has to be examined. Now, in this context, the need for this kind of enactment or this kind of expression related in any relationship in the nature of marriage. This was necessitated because there were several cases where women were dumped, women were abused, women were exploited, and they were left high and dry. The only reason why that could happen is there is no marital relationship. In the context of Section 125 CRPC, when, if in several judgments it has been said that if the lady and the man live together in a household for a fairly long time and they are known to be husband and wife by the society or people residing around them or in general, and they are believed to be husband and wife, then the provisions of Section 125 CRPC can be applied. That is what some judgments have stated with regard to Section 125 CRPC. Now, what happens if a woman, there are so many instances we see in these matrimonial ads, we see so many people changing their names and posting, their profile in the matrimonial ads. I have seen the experience of some girls who have gone and married a man who was 5 or 6 times married, but represented himself to be a bachelor, an unmarried person, gave some identity, and then he married this person. And that is not the first time he was married. He married several other women in that way. What happens to this poor lady? She thinks there is a marriage. There is a marriage performed according to the personal law. If it is a so-called love marriage, they would have registered it in a registrar office under the special marriage act. Still, they are married. But what is the validity? What is the legality of this marriage? According to Hindu law, this marriage is null and void. According to any law, this marriage is null and void, except, of course, an exception is Islamic law where they are permitted polygamy to the extent of 4 wives. So, what is this? A lady is duped to believe that the person who approached her is indeed a bachelor as represented by him and gets married. But he's not married for the first time. There are 2 or 3 subsisting marriages earlier also. What happens to the legality of this marriage? This marriage is null and void. Void ab initio, because Section 5 of the Hindu Marriage Act says that a person marrying should not have a living spouse. And if he or she has a living spouse other than this person, that marriage is void ab initio. So what happens to the rights of that lady? In marriage, there are certain rights of both the parties, and the right of the woman starts with the right to maintenance, right to shelter, and so on and so forth. And if she falls into that kind of impression, false impression, and gets married, what is her right? This particular clause, relationship in the nature of marriage, is intended to come to the rescue of such women who enter marital relationship. It says there. I'll come to the judgments. There are two very important judgments on this aspect. Now, live-in relationship is another situation where a man and woman have lived together without any marriage. They live together the way they want, and there is nothing that binds one with the other legally. He cannot ask for restitution of conjugal rights. She cannot ask for maintenance or other things which normally a wife would be able to ask for in a living relationship. So, when a question came up before the Honorable Supreme Court, whether this relationship in the nature of marriage would include live-in relationship. This is a case reported in 2010 SCC 469, D. Velusamy versus D. Pachiammal. In this particular case, the Honorable Supreme Court very clearly said, laid down certain guidelines and ultimately said that live-in relationship does not amount to relationship in the nature of a marriage. If it has to be a relationship in the nature of marriage, there are certain basic criteria which have to be fulfilled. Now it says, I am reading paragraph 32. Some countries in the world recognize common law marriages. A common law marriage, sometimes called a de facto marriage or informal marriage, is recognized in some countries as a marriage, though no legally recognized marriage ceremony is performed or civil marriage contract is entered into, or a marriage registered in a civil registry. And then it gives its opinion. In our opinion, a relationship in the nature of marriage is akin to a common law marriage require that although not being formally married, these are the basic characteristics the court wants to see to decide whether it is a marriage or not a marriage. I mean, in the nature of marriage, not exactly marriage. Marriage in India would be according to personal law or a registration or even a formal one where everyone, recognizes them as husband and wife, duly married in accordance with law. Now, in our opinion, relationship in the nature of marriage is akin to a common law marriage. Common law marriages require that although not being formally married, the couple must hold themselves, the couple must hold themselves out to the society as being akin to spouses. B, they must be of legal age to marry. This is extremely important. They cannot say that, now the legal age, there is a move to increase the age of a woman also. Now the legal age is 18 years for a woman and 21 years for a man. That legal age is a condition precedent. They must be otherwise qualified to enter legal marriage, including being unmarried. They must have voluntarily cohabited and held themselves out to the world as being akin to spouses for a significant period of time. This is what we have seen in the context of Section 125 CRPC in some judgments of the Honorable Supreme Court. Then, in our opinion, a relationship in the nature of marriage under the Act 2005 Act must also fulfill the above requirements, and in addition, the parties must have lived together in a shared household as defined in Section 2S of the Act. Merely spending weekends together or one night stand would not make it a domestic relationship. So these criteria, they have to hold themselves to the society as being spouses. They must be of legal age. They must be otherwise qualified to get married, including being unmarried by then. And then they must have voluntarily cohabited for a sufficient length of time. It's not sufficient if as the judgment says, living together during weekends or spending a few days together or maybe one night stand and all that, they cannot fall under the definition of persons related in relationship in the nature of marriage. So the act would not apply. In addition to all these, the judgment says they have to have lived in a shared household. Section 2S. Section 2S, you kindly see, a shared household is a house where both the aggrieved party and the respondent are living or at any point of time in the past have lived together. That is the definition of a respondent, where he and the aggrieved person have lived together in a shared household. Either they are living in the shared household at that particular time, or have in the past lived lived in a shared household in domestic relationship. So these criteria plus the criteria of shared household, living in a shared household under Section 2S of the DV Act, that would bring them anywhere close to the expression relationship in the nature of marriage. So this is very important. Now, in our opinion, not all live-in relationships will amount to relationship in the nature of marriage to get the benefit under the Act of 2005. To get such benefit, the conditions mentioned by us above must be satisfied, and this has to be proved by evidence. If a man has a kid whom he maintains financially and uses mainly for sexual purpose and or as a servant, it would not, in our opinion, be a relationship in the nature of marriage. In the feudal society, Sexual relationship between a man and woman outside marriage was totally taboo and regarded with disgust and horror, as depicted in Leo Tolstoy novel Anna Karenina, Gustav Flaubert's novel Madame Bovary, and novels of great Bengali writer Sharat Chandra Chattopadhyay. Now, coming to this is the feudal society where sexual relationship outside marriage is considered a taboo. Now, we are in a society where we are governed by personal laws. And personal laws definitely have a mold which is called morals. And we in our society would definitely consider it a an ideal thing to stick to those morals and be within the framework of morals. And accordingly, our law also thinks in that way, and hence any extramarital relationship cannot come under the relationship in the nature of marriage. Now, this particular aspect is different in U.S. law and in British law. There, even live-in relationship is attracted by this domestic violence act. Any two persons within a household, within a shared household, if there is violence, whether it is physical, verbal, emotional, or economic, that would amount to domestic violence under that act also. But the difference is here, relationship in the nature of marriage does not include live-in relationship. This is specifically stated in 2010 SCC. Now, going to 2014, there is another decision of the Honorable Supreme Court, Indra Sharma versus VKV Sharma, 2014 6 SCC Criminal 593. This was a case where a woman who knew pretty well that a man was already married has relationship with another woman which is legal, has children through her, and he falls into relationship with this woman. This woman also knows that his family members are very strongly objecting to his relationship with this woman, but this woman continues the relationship, and she, at one point of time, is dumped by this man because his wife and children have very strongly stated and convinced him that he should be away from that relationship. So he came out of the relationship and dumped this woman from whom he has taken a lot of money, according to her. And she filed a case under the DV Act, 2005 Act. The earlier case, that is Pachiammal's case, Veluswamy versus Pachiammal's case, that was a case under Section 125 CRPC, but because the provisions of the DV Act are also applicable in the context, that particular judgment has discussed that aspect of the matter. But in this case, very clearly, the wife has filed a case under the DV Act seeking reliefs under Section 18, 19, 20, etc. Several reliefs that are permissible for an aggrieved party under the DV Act. So such reliefs were sought and she filed a DV. Ultimately, it came to the Supreme Court, where the Supreme Court very clearly said this lady knew from the beginning that this man is married to another woman. He has children. She also stated that his family members were very strongly objecting to his relationship with her. And having known everything, she, with her open eyes, has opted to live with him. And she claims this because they were living together for a very long period, that is about 12 to 13 years, as they say, in this judgment, and for that long time they were together, but there was no marital relationship. Everyone knew that he was already married. Nobody considered these two to be married persons. So the relationship in the nature of marriage is not attractive. That is what the Honorable Supreme Court said in this decision. And they have particularly referred to the decision in Veluswamy versus Pachiamal's case. The marital relationship. Marriage is often described as one of the basic civil rights of man, public women, which is voluntary, undertaken by the parties in a formal way, and once concluded, recognizes the parties as husband and wife, and then agreement to be married. That is not existing in India, except in very rare cases. These days, parties come to us asking us to draft a prenuptial agreement when the marriage is essentially a Hindu marriage. So, prenuptial agreement in the context of Indian laws may not be very relevant, but social marriages which are happening, as has been said, community marriages or social marriages, and these when it is in public they exchange garlands, but they intend to live as husband and wife. They are recognized, of course, as husband and wife, and that's why these provisions would be attractive. In the nature of marriage would come into it and all that. But unless that is actually there, that part of that recognition or that living together or the purpose of living together, this judgment in fact describes all the expectations that are between the spouses. When spouses are married, they have certain religious, certain fundamental, emotional needs, their need to get close to each other, their sexual needs, and all these needs, they are recognized as being existent, valid, and legitimate between a husband and wife. But if two unmarried persons are living together, they should, in the judgment of Veluswamy, the Honorable Supreme Court has said that they should not be married, they should be fit for marriage, and they have no other impediments like being married earlier and all. So, relationship in the nature of marriage, number one, does not include a concubine. That word was very wrongly used, and women's organizations protested against that. But it does not include a concubine. Number two, it does not include live-in relationship unless the relationship between them is such that they have lived long enough and have depended on each other for all the aspects, and then they are recognized as such in the society. So that is what this relationship says. Now, once a person comes under the definition of aggrieved party, what are her rights against the respondent? And who is going to decide it? What is the procedure? Number one is, what are the substantive reliefs? Number two, what is the procedure? Number three, which court has to decide that? Now, in all these aspects, when we go to the law related to domestic violence in India, the 2005 Act, there you have Section 18, which says that there can be a protection order, protection from any acts of domestic violence, like abusing, like this, that. And mind you, there is one more important thing in this matter. This, in the nature of my relationship, in the nature of marriage, relates to only persons claiming as spouses. But understand one thing, this relates to persons who are related, who live or have lived at any point of time in a shared household, who are related by birth, which means it can be between brother and sister, it can be between father and daughter, it can be between other siblings, and one lady, and it could be between anyone. See, under law, there are several rights which a woman has. An unmarried girl definitely has right of shelter under her parental house. An estranged wife also would have right of residence in the father's or parents' residence. Now, these are rights which are recognized by law. These are rights recognized by law. And all those rights which are recognized by law, if a woman is entitled to a certain right under any law, and if that right, if the respondent prevents her from getting that right, from reaching that, receiving that benefit under that particular law, that would amount to domestic violence, and a woman can seek domestic violence. Now, visualize a situation where the head of the family is no more. Now, there was a recent case in which a lady came to me. She and her brother are the only children of her parents. Her father left a palatial house. Her mother left a lot of jewelry. Her brother works for an organization. This lady also works somewhere. Now, when this lady expressed her desire to get married to an ex person, to a person X, this boy got mad. He did not want the sister to get any kind of benefit from any kind of benefit that she is entitled to. She is entitled to share in the property. She is entitled to jewelry. Their maternal grandmother gave her just some jewelry. That boy complains to the police saying that my sister has stolen away my jewelry. Where does he get the jewelry from? What is the source? He has to explain. So, in such a situation also, criminal case is one remedy, definitely. But this Domestic Violence Act provides remedy for such women also. Now, she wants to have the property partitioned. The brother is obstructing, harassing her. Her original certificates, which are required for marriage, were to be taken. In fact, I think today she got married. The original certificates which are to be submitted for the marriage were within the house. He didn't permit her to go into the house. He broke open the lock and he changed the locks. And when this lady went to the police station to seek police help for recovering her originals, this man complains to the police that she has broken the lock and changed the locks. So this kind of brilliant ideas pass through so many people's minds, and such harassment also is covered by this act. There can be a prohibitory order against this man, and there can be an order for, if she is entitled to a share in the property and if he is obstructing, if she has a share in the property, she has a right to residence in that. And coming in the way of her living in that house is definitely economic abuse under the provisions of the DV Act. This is one example. So, this particular law is not just a law between husband and wife. This is a law, in relation to any two persons living in a shared household or have at any point of time lived in a shared household and related to each other. By, they're related to each other in domestic relationship. So this is this is a this act is having a very wide scope. We cannot restrict it to something like 498A or maybe 125 CR. 125 CRPC is also very wide. But this act gives some wider things. See, so far as maintenance is concerned, this act, let us go in a sequence. Section 18 is the section which empowers the magistrate to pass an order of prohibitory order, where the respondents would be directed not to indulge in any acts of domestic violence. and violation of that act, that particular order under section 18 tantamounts to an offence. It's a cognizable offence under section 31 of the very act. Section 19 provides for protection with regard to residence, right of residence. This act in section 17 says every woman has a right to shelter in her matrimonial home, whether it is the own house of the husband or own house of the respondent, or whether it is a rented house, or whether he is having any share in it or not. So, the right to residence is recognized under this law. Whereas is this right to residence recognized? This right to residence is recognized under all the maintenance laws, because the Supreme Court has very clearly in its judgment stated that maintenance would include shelter, right of residence. Here, this a woman can ask for right to live in the house where she is living in, that is the shared household. But there is one exception. There was a case where the daughter-in-law sought to enforce the right of residence against her in-laws. Supreme Court has stated in that particular case, Batra versus Batra. I'll just give you the citation. In Batra versus Batra, the Honorable Supreme Court says the right of a woman to enforce the right of residence would be confined to the residence in which her husband is having any share, or is a tenant or in respect of that premises, or he owns that premises. But she has absolutely no manner of right to enforce that kind of, you know, enforce that kind of right against the in-laws. It is Batra versus Batra. I'll pass on the citation to Mr. I'll pass on the citation to within the group as soon as I'm through with this. All right. Then a woman cannot claim right of residence as against the in-laws if the house belongs to in-laws. They can very well prevent the daughter-in-law from living there if the husband is not living there. Because if the husband lives, even she has a right to live there. Whether it is a portion which he owns, which he rents, or lives there as a licensee or as a family member, she would have a right. As long as the husband is not there, she cannot enforce any right of residence against in-laws. That is what the Supreme Court has stated very clearly. So that is section 19, right of residence. Section 20, you have so many, financial reliefs. You can ask for maintenance. You can ask for return of Sridhara. You can ask for so many things under that. Then you also have a provision which says that you can ask for compensation for monetary reliefs under section 20 would also include compensation for the domestic violence, for the acts of domestic violence to which the lady is subjected to which the aggrieved party is subjected to. Now, this particular provision, when this act came into force, I was one of the persons who was very happy, and I went about, holding orientation programs in several places, including one for, judges in a district, in a whole district when they were having a judges conference. At that point of time, when we just saw the law, it was so encouraging, so wonderful. Residence, maintenance, Sridhana, Section 21, custody. Custody under section 21, if you can kindly see, it empowers the magistrate to give custody only to the aggrieved party. There is no provision that the magistrate can give custody to the respondent. Please see section 21. Custody orders. Notwithstanding anything contained in any law for the time being in force, the magistrate may, at any stage of hearing of application for protection order or for any other relief under this Act, grant temporary custody of a child or children to the aggrieved person, or the person making an application on her behalf, and specify, if necessary, the arrangements for visit of such child or children by the respondent, provided that if the magistrate is of the opinion that any visit of the respondent may be harmful to the interests of the child or children, the magistrate shall refuse to allow such visit. What does this mean? This means that a magistrate may order interim custody of a child only in favor of the aggrieved party and not in favor of the respondent. He may at best give visiting rights to the respondent. And if he feels, in his wisdom, that it is highly detrimental for the minor to be sent for visitation, or if the respondent visits him, then he may say no such visitation. Then section 22 deals with compensation. It's not section 20. It is section 22 which deals with compensation for acts of domestic violence. This is an area which is highly disappointing, because how do you value the quantum? How do you arrive at a quantum of compensation? What are the guidelines? Nothing in the act or nothing in the rules to, in the form of guidelines for the purpose of determining the compensation for acts of domestic violence. For a woman, if a man hits her on her face, on her hand, anywhere, or indiscriminately, will that be more painful? Or will the fact that her husband or her brother or her father is suspecting her movements, suspecting her character, which would be more harmful? There are several instances as an advocate, and when I talk to clients, I feel very sorry for them when they complain that I do everything at home, then I go to work. I cook for my husband, I pack his box, I cook for my in-laws. I do everything, I keep everything ready for my children, and then I go to work. If by any chance my cab or my bus returns a little late and I am 5 minutes or 10 minutes late in arriving at home, the question my husband and my in-laws ask is, ఎవరితో పడుకున్నావు, ఎవరితో పోయావు, ఇంత లేట్ ఎందుకైంది? Hope everyone understands what I said. With whom have you gone? With which fellow have you slept? Why are you so late? So if a woman comes late, it means that invariably it is this. Please try to figure out which is more painful for a woman, which kind of torture. Whether hitting once or twice or maybe daily is more torturous. Of course, just hitting, not injuring very badly and all. Or whether abusing a woman, suspecting her character, casting aspersions on her character is more painful for a woman, which would amount to violence which is more serious. How do you compute the compensation? And this particular section, if I may read it, In addition to other reliefs as may be granted under this Act, the magistrate may, on application being made by the aggrieved person, pass an order directing the respondent to pay compensation and damages for injuries, including mental torture and emotional distress caused by acts of domestic violence committed by the respondent. Now, what does this mean? Mental harassment also is something which is domestic violence under this. Physical harassment, mental harassment. Now, this section or anything in this act or the rule does not say that this compensation has to be commensurate with the income of the respondent, or it has to be commensurate with the means of the respondent, with the assets of the respondent or his total value. It doesn't speak about it at all. And then one more thing here is the cases under this law are triable by magistrates who are fresh entrants into the judiciary, in the subordinate judiciary. And they would not have experience in adjudicating in matters like this, especially when there are no guidelines. And then what happens? Who can calculate what trauma that lady has gone through? There is a case of one particular person from our profession with his against his wife. The story there is terrible. Of course, it is sub judice, so I may not narrate the entire details of that. But she opens her mouth, he bashes it. If she goes out, invariably this question, with whom have you gone? But when it comes to him, he's a free man. He would bring any woman to his house. And if the wife looks at them, she's finished. This is the kind of violence. How would you calculate that? Definitely something in the rules has to be incorporated, or the officers who are adjudicating should be sensitized. This is my opinion. Then, these are the main reliefs under the Act. Now, the provisions of the Act, if you read as a whole, would indicate that this Act has retrospective effect. Before that, let me also say that a complaint can be given either to the protection officer appointed by the concerned government or directly into the court. Once a complaint is given to a protection officer, the protection officer is required to make a domestic incident report. A domestic incident report, what a lay person would understand it as, that person would come to the house of this person, where to the house of the aggrieved party, find out the situation there, and make a report after a first-hand inquiry. But in how many cases? To my knowledge, there is not even a single case in which such kind of domestic inquiry has been done. Domestic incident report. Domestic incident report has to be done after making due inquiry, that goes without saying. But no such exercise is done. Instead, there is a printed form in which certain tick marks have to be put and certain things have to be scored off. That is the DIR that they are submitting in the court. And when the case is directly filed in the court, it goes to the protection officer for DIR, and they take any number of months to do it. That's a different aspect. The whole system has to be overall for the effective implementation of the Act. Now, this is having retrospective effect, this Act. Please see how. Who is an aggrieved person? Aggrieved person is one who complains of domestic violence by the respondent, where both of them are living or have at any point of time lived together. It does not mean that they are continuing to live in the same house, so there is domestic relationship. No. Even if they have lived together in a shared household sometime in the past, the provisions of this act would still apply. Then I would definitely ask everyone to read section 26. It is a wonderful provision, but that it is always followed in breach, at least to the extent of the state of Telangana and Andhra. I know Bombay, I know Delhi, and state Pune. These courts are entertaining this very regularly. Like section 26 says, relief in other suits and legal proceedings. Relief in other suits and legal proceedings. 1. Any relief available under section 18, 19, 20, 21 and 22 may also be sought in legal proceedings before a civil court, family court or a criminal court affecting the aggrieved party and the respondent, whether such proceeding was initiated before or after the commencement of this act. Which means in previous proceedings also, you can include this relief. Number 1. Any relief referred to under subsection 1 may be sought for in addition to and along with any relief that the aggrieved person may seek in such a suit or legal proceeding before a civil or a criminal court. And number 3, in case any relief has been obtained by aggrieved person in any proceeding other than the proceedings under this Act, she shall be bound to inform the magistrate of the grant of such relief. Now, why I am emphasizing on this section is, number 1, it says it can be initiated, it can be also adjudicated upon by a civil court or a criminal court or a family court, where between the aggrieved party and the respondent, proceedings have been initiated even before the enactment. And then all the other provisions also say, if they are living together in a shared household or at any point of time have lived together in the shared household. So, this act has retrospective effect. And to this effect, there is a judgment of our High Court, 2010 1 ALD Criminal, page 1. That was instantly a case which I argued on the point that this act has retrospective effect, and my argument was upheld. And one more thing, in my observation as a practitioner, section 26 empowers other courts also to ask for any relief under this act. But I have filed cases in the Family Courts Act under section 13 or maybe under section 12(1)(c), narrated all the acts of things of unfortunately a working woman cannot ask for alimony. What can she ask for? Compensation for the harassment that she has gone through. This act provides for compensation, and this act also provides for this relief to be granted by any court other than the magistrate's court, where both of them are litigating. It could be a civil court, it could be a criminal court, and it could be a family court. But why aren't we getting that? That is another point which has to be agitated. This particular point, when it came up before the National Judicial Academy in the recent past, basically it was all class for course for district judges from all over the country, and it was almost felt by everyone. There is one barrier in this act, the DIR. If DIR is necessary, and if this relief is sought in a pending case or a case or a matrimonial case or in a civil case, then what happens to the DIR? So everyone uniformly felt. In fact, I proposed that kind of thinking that where it is exclusively economic abuse, there need not be any domestic incident report. And so far as economic abuse is concerned, it can be effectively adjudicated upon by the civil court, criminal court, or the family. And I still feel that if all of us solidly, try to get this thing, we need not drive our clients for multiple reliefs to different courts and file number of cases. Now there is a package, number one, 498A, give a complaint. Number two, DV case. Number three, 125 CRPC. And number four, to top it all, restitution of conjugal loss. Now this has become, a package which so many advocates are guiding clients into. And well, God bless them. If it clicks, it's very good for them. But what I want to say is, as easily as possible, we have to guide our clients to reach their destination, which is a solution. Solution through the process of law. If it is a negotiated settlement, that is the best thing to happen. But when, driving our clients to several, so many cases, when you can ask for all those reliefs in one act, for example, not just the DV Act, in a case under Hindu Marriage Act, you can ask for permanent alimony under Section 25. You can ask for child custody and child maintenance under Section 26. You can ask for return of property under Section 27. Interim maintenance you can ask under Section 24. All these provisions are available to us. But there are many of us who would ask our client to file number one, a petition under 1311A of the Hindu Marriage Act, number two, under the Guardians and Wards Act, number three, under the CRPC, number four, under the DV Act. So many cases. Why? When we can do all those things in one, and this particular provision is an enabling provision so that multiplicity of litigation can be avoided. And we have to probably concentrate a little more on focusing on this particular section. So this is about it. Then jurisdiction, of course, where the aggrieved party resides. Then there is one thing under this act. Procedure, as I have said, Section 12 petition has to be filed before the magistrate and all that. One thing is very important in this. This act is in addition to other laws and not in derogation. Section 36. Protection of action Act is not in derogation of any law, any other law. The provisions of this act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. Maintenance. You have 125. You have Hindu Adoption and Maintenance Act. For Muslims, you file suits, now OPs, for maintenance under the general law. Special Marriage Act, you have provision for alimony, you have provision for interim maintenance, other things. Divorce Act, you have provisions for maintenance. There are so many laws which provide for maintenance. This law also provides for maintenance. So this is in addition to whatever laws are in existence. And then, if any relief has been granted by any other court, you can still file a case under this. The only bar is that you have to mention what relief has been actually granted. I think my time is over. A little disturbance I can notice. Am I right, Mr. Mahambu? My time is over?
Uh, you can speak more, ma'am. No worries about that. So
I think we'll take the rest of the time for interaction.
okay, ma'am. Thank you so much. Thank you so much. I have been following, uh, you know, this thing well so far, and it has been very educative, very enlightening, and a lot of new points have come up, and uh, regarding what do you call my suggestion to our participants is kindly please write your questions. Ma'am has spoken more than 1 hour. I think it was a fantastic lecture. We have been listening about domestic violence, and I'll just come to the enumerate all the topics. But suggestion to you guys is, if you have any question, please write down so that ma'am may answer. That is one thing. And if you want to use your mic, just put there that you want to ask a question. We have seen,
One request, Mr. Mehboob.
yeah, yeah, ma'am.
If anyone wants to personally talk, let them have their video and voice on.
Okay, okay,
I
okay,
would like to see who it is. Okay?
okay. Yes, guys, you can also use your video. Okay. There are certain requests for continual of lecture, but we have more, what do you say, this meeting can go till 8:10. It depends on ma'am. I believe
No,
I'm seeing that attendees, the number of attendees are not getting reduced, but depends on ma'am and the other participants.
no problem. See, knowledge has to be shared. The more we share, the more we get it. No problem.
Okay.
I have a question to ma'am. Hello, ma'am.
Yeah.
Can you hear me?
Yeah. Your name, please?
Yeah, my name is Abdul Razak.
Yeah, tell me.
The question is, ma'am, the domestic violence is for only the wives. Are suppose if wife hits to husband, if wife harasses to husband, the husband also will go under trauma. Will section 13 and 12 will support or help to the husband for the appeals and all?
No, this is,
Because he'll be the aggrieved person, is it not?
see, not under this law, because this law is exclusively meant for women.
Exclusively for him, because you
For
are
women,
as an intellectual for law. Strange question, of course, I admit. So, what is your? I mean,
My
today we
my
are
re-
talking about the DV Act.
yeah.
So far as
yes,
the DV Act is concerned, under
yeah,
Article 15, this law was passed because women, laws for women definitely are
yeah,
permissible under Article 15. So this is
uh,
definitely an exercise of the powers under Article 15, and this
yeah,
law is meant exclusively for women. For men, if they are harassed, number one, if it is a Hindu husband, probably
yeah,
he could go for divorce on the ground of cruelty, or the general law is there, IPC is there.
uh-huh. Because in reality, there are some cases. Of course, it is sort of strange question,
See, it may be
but
20%. It may be
it's
20%.
coming.
But today, a woman
Yeah,
is still
yeah.
harassed. You know, the tragedy
I
is,
agree.
there
Yeah,
are so many women who file false cases, with the result
yeah,
that the genuine
yeah,
sufferers are not getting justice these days.
yeah. Because we have seen some cases, the husbands also were beaten by the wife, and
Yeah, I have clients like that also.
uh-huh.
Definitely, I have clients like that also. I'm not
Yeah,
confined to women so far as my profession is concerned.
yeah. So
Ma-
you mean to say section 12 and 13, these sections won't help him?
Sorry?
The
Section
section
12,
12 and 13.
Section 12(1)(c) of the Hindu Marriage Act is for annulment. Annulment is a totally different story altogether. It is annulment
Uh-huh.
on the ground of fraud, etc., etc. Section 13 is divorce. Divorce 13(1)(1)(a) would be under the on the ground of cruelty.
I see.
That is a commonly
Anyhow,
used ground.
thank you, ma'am. Thank you.
Well,
Ma'am, I would like to ask one question to you, ma'am. This is Mehboob here. So the question is for men who are not working, is there any maintenance money given when a wife is working? And uh, yeah, go ahead, ma'am, please.
See, that under this act, no, but definitely under the marriage laws, you see Section 25 of Hindu Marriage Act, corresponding provisions in the Special Marriage Act and Divorce Act. Definitely, either of the spouses can benefit from that. There was a case in which a case of annulment filed by the wife, husband filed something which I have handled. Husband filed a petition for interim maintenance in that. The district judge granted him 2,000 per month. This was way back in 2004 or 2005. And I filed a revision against that. It was suspended and ultimately it was vacated. The general rule is that an able-bodied man is capable of maintaining himself and his family. If he has any disability, definitely the other spouse will have to look after. In the normal course. Yeah, next, ma.
Yes,
Ma'am, good evening.
Good evening.
Myself, Kirti. Question is that actually, where the incident has taken place, they have to file the case in the same PS, or else they can file the case where the marriage is performed.
Even where the lady is temporarily residing, she can find that the choice is hers.
Okay.
The choice is there. Where the incident happened, it can be filed in that jurisdiction. Where she is a permanent resident, that jurisdiction also can be invoked. And the place where she is temporarily residing, even that jurisdiction can be invoked.
Okay, ma'am. Thank you.
Welcome.
Hello.
Ma'am, any inputs to the younger generation lawyers, future advocates?
Future advocates, I always tell everyone there is a fundamental rule which I follow. See in pictures, write in words. Drafting is a very important aspect of practice. When a client narrates to you something, you see it in pictures and narrate it in words, so that when the judge reads it, it will look like a picture. That is the fundamental you have to follow. Not this facts will speak for themselves. We will speak about it.
Thank you, ma'am.
Right.
okay. I'll take some question from the chat box.
Sure.
One question is coming from, I think, Sunita Rao. She's saying, can the domestic violence incidents report be drawn with regard to both respondent and the complainant? Okay.
Domestic. Sunita Rao has asked this question, is it?
Yes.
All right. Domestic incident report has to exclusively relate to the acts of violence, domestic violence complained of by the aggrieved party, and it has nothing to do with any so-called acts of violence of the aggrieved party. It has to confine itself to the acts of violence complained of by the aggrieved party.
Okay. So next question is Mr. from Azhar. Sometimes these days this law is taking in wrong way, means unnecessarily harassing men. So what are the sections in this law preventing such incidents? So simply speaking, it's like a question where sometimes the law is used in a wrong way, as you were suggesting some time
Abuse
back.
of law, yes. Misuse and then abuse of law also is very much there. See, we should have a system. See, we should try to filter it out at our level also. Definitely, we should try to filter it out at our level. Number one, this is a trade secret I'm sharing with all of you because all of us are belonging to the same family. I insist that my clients should send their written narratives. Mail it to me or give it in writing, but it has to be given in writing so that the actual picture is there. Tomorrow they cannot come and say you add this, you add that, all the false stories and all that. We don't encourage. We ask the client, either actually we have a form. In the form we have a column brief facts. Those brief facts column will not be sufficient to narrate the whole story. When they come to us for the first time, they come with the form. We have the basic fundamental facts there. We talk to them. When we talk to them, as I said, we see a picture, and then we ask them to follow it invariably by a narrative, a detailed narrative, in which, if it is embellished by some falsehood, we can't filter it out. But if they write the truth in that, which normally the advocates do, there should not be any problem. We cannot further, go and at our level, we should try to filter it out that way. I know of many practitioners who would say, if you write this damn thing, nobody will take it seriously. But no, that has not been my experience. When we write the truth, write it so that they see a picture. They see a picture. That is the importance of seeing in pictures and writing in words.
Okay, the next question is saying, does harassment differs from situation of the family? Bhavani is asking, does the harassment differs according to, I think, situation of the family?
What amounts to harassment under this particular law is, physical harassment, mental harassment, verbal harassment, sexual harassment, psychological, and economic abuse. All these abuses, they constitute acts of domestic violence. Now the question is, I'm sorry, please repeat the question. The question is that what would constitute, please repeat the question.
The question is, harassment, does it differ from situation to situation of the family?
It will differ. It will differ in the sense that we see so many people on the streets. Husband and wife come out of their small houses, they fight, they beat each other, they abuse each other in the dirtiest language. But next morning they are together. She cooks for him. Ayya Tondargara comes back fast from work, they say. There are, Supreme Court in the context of cruelty has very clearly said that whether a particular act amounts to cruelty or not would depend on the facts and circumstances of each case, and more so on the nature of the parties, on the sensitivity of the parties. The more a man is educated, or man includes a woman, of course, the more a person is educated, the more sensitive he is considered to be. And a sensitive person, if you say a small thing also, would get upset very fast. And in the context of shared household, in domestic relationship, definitely each person would know how sensitive the other person is. And if that person actually harasses, if that person knowing fully well that this particular word is going to provoke him, this particular word is going to harass him, definitely that would amount to domestic violence. It differs from situation to situation, it differs from person to person also. Something said in anger may not amount to domestic violence. Like in IPC also, something done in grave and sudden provocation that is punished, attracts lesser punishment. Something which is said in a spur of moment. That is not domestic violence, strictly speaking.
Okay, Radhika is asking how to calculate the maintenance amount as per salary. Is there any percentage?
See, there, if you see section 60, section 60 says the entire salary, there cannot be deduction exceeding 1/3 of the salary. That is in ordinary case. In the case there is maintenance, it cannot exceed 50%. That is the main thing. That is the main thing you have to consider. Number two, it is not just the income. If that man, if the respondent is earning, let us say, 2 lakhs of rupees, but I don't have expenditure, the wife does not have expenditure of, even if she puts everything together, it may not exceed 10 to 15,000. Just because that man has that much of income, there is no rule that he has to pay. There is a balance that would be struck, that has to be struck between the needs of the aggrieved person and the means and means. There has to be a balance. Means of the respondent, needs of the wife. Or if there are children, children's maintenance, children's school, children's clothing, children's, everything, their food, their extracurricular activities. That would again depend on the husband's income, whether he can afford that. And there is a judgment of the Supreme Court also which says that when both husband and wife are working, they should contribute towards the maintenance of the children in proportion to their income. If the husband is earning 2 lakhs and this lady is also earning 2 lakhs, they share 50-50. If one is earning 1 lakh and the other is earning 2 lakhs, they would share in the ratio of 2:1. The person who is earning 1 lakh would contribute 1/3, and the person earning 2 lakhs would contribute 2/3. That is the rule.
Okay, Kiran Thakur, I'll come to your question. Kalpana is asking, can sister-in-law file domestic violence case on brother's wife?
Sister-in-law,
Can she file a case on brother's wife, like her sister-in-law?
can sister-in-law, if they are residing in a shared household and related through birth, they are related through marriage, co-sister or sister-in-law, husband, sister.
Husband, sister, and like sister-in-law.
Husband, sister, and sister-in-law, they are related through marriage to her.
Right.
That definitely can be filed. Okay. And if the condition is they have to be living under the same roof, or at any point of time have lived in the same roof. And going to that, when we were discussing about relationship in the nature of marriage, it is not just weekend living together, or it is not just a few days living together and all. Living together, leading their lives under one shared household. That is a prerequisite. If they are doing that, definitely, it can be filed.
Okay. And Akhila Tabasum is asking, is a earning wife liable for any kind of amount to be paid if it is a mutual divorce?
Mutual divorce is always based on mutual consent.
Okay.
What one gives, what one takes is done mutually. Only after everything is decided, they come mutually. If there is a situation where I know of a celebrity to whom the husband gave a bulk amount to be, invested or to be, used for promoting her profession and all that. And when they came for settlement, for mutual consent, that happened in family court, Hyderabad, that lady offered to give back that amount to her husband because she's earning and the husband wanted it. She was ready to give that amount to the husband. But the court said, no, don't give it to the husband, give it to the children. So, what is done by mutual consent is essentially something agreed upon by both parties. It has nothing to do with each other's income. There is no yardstick to measure the quantum of maintenance or quantum of compensation or quantum of alimony that one has to pay to the other if it is a mutual consent. Normally, when it is mutual consent, what we advise is, supposing legally if it is a lady whom we are advising, we tell that lady, supposing you are entitled to this much in law, if we go by law after a fight, you will get that after 5 years or maybe 10 years when it happens, when the case is closed in the High Court. What you do is, you take this much, be satisfied with this much, and you think the rest of the amount you have spent in buying money. Buying time. You don't get time in the market. You spend crores of rupees. You cannot buy a single day in your life. You cannot get back a single day in your life. You think you are buying time in your life with that money which you are taking less. And if it is the husband, we normally advise. This is the same thing. The reverse we advise. If you are prepared to give this much, you give this much, so that you think with the rest of the money, with the extra money that you are now paying, you are purchasing so many years in your life, which is not otherwise possible.
Okay, ma'am. Kiran Thakur is asking, a girl, that is, I believe it's a wife, is a government employee and she is from Guntur. And the boy, I believe he's referring to husband, is from Hyderabad. After marriage, she did not take transfer, and hardly 1 or 2 times she visited in-laws' home. And through their marriage, they have a female child. She is not ready to move to Hyderabad, and she is asking her husband to move to her place where he is also not okay. And both want to proceed with divorce. Can the boy file from Hyderabad? As the girl is working, she cannot travel, then can the case will be transferred? Please.
See, number one, with regard to jurisdiction, if it is a Hindu marriage, or generally, the place where the parties married. Number two, the place where they last resided together. Number three, the place where the respondent is living. These are the general things. But for a woman, the place where she is residing is also having jurisdiction. So these are the 4 choices. Now, if the husband files a case in Hyderabad, definitely the wife can seek a transfer from Hyderabad to Guntur. But for that, she'll have to go to the Supreme Court. Because earlier, it was a common state and then the High Court could do that job. But now, the High Court would not have the jurisdiction to entertain that. It has to go to the Supreme Court. It will definitely be transferred. More so, if the child is living there and if she is an employee, she cannot travel back. And there are cases in which the Supreme Court has also dismissed transfer petitions saying that exempt him from attending or exempt her from attending.
Next question is asked by Ruxar. She is asking, if a wife is not taking care of mother-in-law and father-in-law, can the husband seek a divorce?
Taking care of mother-in-law and father-in-law is a duty which is cast upon a woman in this relationship called marriage. If she is a working woman, definitely she cannot be expected to do everything. If she is idle at home and neglecting the in-laws, maybe that will be a very harsh thing for a husband. And maybe he can treat it as cruelty and ask for divorce on the ground of cruelty. And if it is a Muslim, I need not tell anybody. It is a very simple thing. I mean, now of course it is triple talaq 3 times. You have to give a gap of 1 moon cycle for each. The pronouncement of talaq, talaq-e-bain. You pronounce once, give 1 moon cycle time, second time, and then another moon cycle, and then the third time. It cannot be done in one breath as it used to be done earlier after this amended law.
Okay, ma'am. Kishore is asking, in a maintenance case, if husband is not paying monthly maintenance to wife from 6 months, what type of petition should be filed in district court, under which section, to recover the money? Is there any section if husband is not paying this
So is there
maintenance?
an order for maintenance?
I'm sorry?
Is there an order for maintenance?
Okay, Mr. Kishore, can you please tell, has the wife already received some order in her favor that the husband has to give?
Okay, good evening, ma'am.
Good evening, tell me.
Yeah, the order has given, judge has given for 4,000 rupees monthly maintenance
Under
to
which
wife,
provision?
madam.
Under which provision? Which case?
In MC, madam.
MC, you have section 126, isn't it?
Yeah,
If he is working, you can ask for his salary attachment. If he is not working, if he has the movable property, you ask for that attachment, and the revenue officials will sell the property and deposit it in the court, and the court will give you. And if he is having mobile properties can be also attached and sold, and it can be recovered. Or if that man is so intelligent enough so as to not to keep trace of any of these things, then she can ask for his arrest. Definitely you can file a petition under section 126.
Section 1. Okay. Thank you, thank you.
Okay, we have let's take 1 or 2 more questions. We have very less time, so we'll ask Mr. Razaki asking, if a daughter-in-law is harassing a mother-in-law and father-in-law, can they file a domestic violence case against their daughter-in-law?
Yes, definitely. Not the father-in-law, but mother-in-law.
Okay, okay. Any more question, guys? Any more questions coming from your side?
Yeah, hi, good evening. This is Safi.
Okay.
Madam, nowadays it is found that many cases which is filed under 498 and EP Act, which are fake. So, can we take any action when it is disproved in the court?
See, 498A cases, a huge percentage of 498A cases end in acquittal. Very few end in convictions. The reason is either the parties get fed up, decide that they want to split, or decide that they live together, close the case, and be done with it. Or after so many years of the commencement of, after so many years of the case being registered, let me tell you, in my experience, if there is a case under 498A and if there is a divorce case, the divorce case would be over first, and then the 498A would come. By then, the witnesses would forget everything. It is very rare that things would be remembered for such a long time. So that is the reason why. And in cross-examination, if there are omissions, contradictions, we know what is going to happen. They will end in acquittal. There will be a substantial doubt and they will end in acquittal. So these 498A cases, many of them are false. Most of them are filed to put pressure on the other party to settle the matter this way or that way. And there are few cases which are actually filed by women who have suffered. Those cases never see the light of the day. And even if they see the light of the day, they are taken very lightly. the investigating officers take it very lightly, and even they won't succeed.
Okay, Mr. Vastu wants to ask a question. Let me. Can you speak, please? We are unable to hear you, sir. If you could remove that earphone, that maybe I'm talking about from the computer. Please remove it from the computer. Maybe the default mic will work with your computer. Please remove that wire from the. I'm really sorry. We cannot hear you. We can't hear you. Sorry. Please type the message. Keep the video on. Please type the message.
చాట్ కి వెళ్ళి మెసేజ్ టైప్ చేయండి. చాట్ కి వెళ్ళి మీ మెసేజ్ టైప్ చేస్తే అతను చెప్తారు.
Can't hear. Sorry, can't hear.
Yeah.
This would be the last question we can take. We are ending our time, the meeting scheduled time. Let us see. Okay, let Mr. Vastu Sampath keep writing, because this is at the end of the session. Let me first do the concluding honors to our honorable speaker, Miss Vani Suri Madam, for being generous enough to take her very valuable time and giving such fantastic lecture for us. This is not a very ordinary college lecture. A practitioner with what do you say, immense amount of experience. She's giving the best wisdom advice to new lawyers, and she's taking the Bayer Act and she's commenting on all sections and how they have been interpreted at various places along with the case laws, and to be said that a lot of trade secrets are also suggested about how to handle cases. And I think this was a very fantastic, enlightening, and also motivating lecture for us to read more about the DV Act with a very new perspective. And we are very thankful to Madam from the platform wakilsahab.com, that and we are very much delighted to to have heard your lecture, ma'am. Thank you so much.
Thank you so much, all of you, for the patient hearing.
Yes,
and I
ma'am.
hope you have benefited. And let us meet sometime again. Thank you so much. Thank you.
Thanks a lot, ma'am.
Thanks
Thanks
a
for the
lot.
valuable information.
Thanks a lot to the organizers for giving me this opportunity, this platform. This has been very interesting. Thank you.
Thank you so much. Thank you so much, ma'am. Friends, please log on to wakilsahab.com for regular updates. We are on Facebook, LinkedIn, Instagram, Twitter, and also we have a WhatsApp group for the updates. And we have many talks, many lectures, other activities coming up in the coming days. And we have free training for All India Bar exam and CLAT exam. Just now we got a news from the Bar Council that AIB exam is being postponed. So you guys have pretty some good time if you are a new advocate. So thank you so much, and I thank from the bottom of my heart that it was a privilege listening to Madam. And thank you so much, and have a great evening and great night. Thank you so much, and I'm ending this meeting. Thank you so much.
Thank you.
Thank you, Madam. Thank you so much.